Hi, my name is David Myrland. In God we trust, our national motto. Under attack. Not a surprise really, but what I'd like to personally underscore about the decision we're about to cruise through, you got to be a really small-minded individual to pursue getting this phrase removed from our currency. What are they teaching children about Vaseline and vegetables in grade school? And you're after this phrase on our currency? Capitalism and free enterprise, greatest opportunity on the planet to be somebody all on your own. And you're attacking the currency that you should be out earning by the tons because it's everywhere. Unless you have other pursuits. And I mean big ones. Righteous ones. Removing this from the currency, really, you're a pissant to try this. The decision, first off, none of this is legal advice, anything that sounds like that to you. Just consider it something somebody else might do on a planet far, far away where the law matters. It doesn't matter here. I prove it on a daily basis. Believe it. This is an appellate decision. It's not a Supreme Court decision. One level below the Supreme Court, the Sixth Circuit. The Sixth Circuit, the first case that comes to mind is because it's a great case, is U.S. versus David Lanier. David Lanier was a Tennessee Chancery judge hearing divorce cases and would invite divorcees to his office, his chambers, to discuss possibly working for the court or custody of the kids. And he took to raping them in chamber. And the indictment was held to be inefficient. It didn't state a claim because the 18 U.S.C. Section 242, deprivation of rights under color of law, didn't reasonably warn him in advance that raping them would violate their rights. And two women from the DOJ took that case to the Supreme Court, and the Supreme Court overturned it, saying that's an entirely new standard. They said, since there was no Supreme Court case with similar facts, there's no way he would have known. And the Supreme Court said, no. Anything on the appellate level is clearly established law. So anyway, the Sixth Circuit, it's legal to rape women in chamber if you're a judge. U.S. versus David Lanier, a must-read, 1997, I'm pretty sure. In God We Trust, remove it from the currency. This case decision just came out. It was featured on Jay Sekulo's program. I watched that on Periscope TV. I urge you all to do same. A whole bunch of plaintiffs sued for removal of the phrase, the national motto, from the currency to get a copy of this that does not have the highlighting that I've used in this. You can go to this. See what this makes me do? I have to leave that mode to access the bubble. There's the web address. Click on pause. And then enter that. And bingo, you'll have this document without my highlighting. So a whole bunch of plaintiffs. And the district court, they sued Congress. And they later dismissed Congress as a defendant. The plaintiffs did. United States of America, Department of the Treasury, United States Mint, United States Bureau of Engraving and Printing, obviously, governmental. The American Legion, American Center for Law and Justice. I have a feeling that they joined this as amicus, maybe as a joinder. So they're listed as an interested party on the appeal. And we have three judges. One, Judge Moore, is in the dissent in this case. And this is where I'm going with this exercise here. The basis for the dissent. They dismissed the civil suit because it did not state a claim, according to the district court judge. You have sued to take the phrase off of our currency. We find that you have not stated a claim because you haven't proven or you haven't alleged a substantial burden on religious freedom, religious beliefs. There's a bunch of other criteria, and they get into it here in this case. But in particular, there's just one aspect on which, or about which, Moore disagrees with Norris and Stranch, the other two judges. Judge Moore, again, there's Karen Nelson Moore, Clinton appointee, confirmed 6th Circuit, 1995. And this is, Stranch, I can't remember her name for the life of me. My mistake. But this is about Judge Stranch. And they don't give you her first name right here, do they? Anyway, this third one is Norris, Alan Eugene Norris, 83 years old, been there forever, 6th Circuit. And they dismissed the lawsuit saying, the United States District Judge, one judge, dismissed the lawsuit saying it doesn't state a claim. And so this is about whether or not the lawsuit states a claim. If the appellate court decided, yeah, it states a claim, then they remand it to the lower court and they proceed with the case. But here, two judges agreed that the claims should have been dismissed. And so it was dismissed instead of remanded. And the dissenting judge is who I want to focus on. Judge Moore held that the phrase on a dollar bill, on the currency, that they did sufficiently allege a substantial burden on religious beliefs, or the substantial burden on the exercise of religious beliefs. Incredible. For something so trivial to actually win the favor of an appellate judge. It's so frivolous, I can't believe it. You're here. Does anybody else anywhere in the world protest having to use the currency of that country when you know darn well all over the world you'll find religious symbolism and images of or expressions of a belief in a deity, and nowhere does anybody sue? So these people are really very, very small individuals with closed eyes and closed minds. And that would be blah, blah, blah. Plenty of them might be used as a tool. But then you get to these organizations. Michigan Atheists, Northern Ohio Free Thought Society. Ah, okay. Yeah. And it's a substantial burden on religious freedom to have to involve yourself with that phrase. Here comes the decision. I'm only going to touch on probably the parts that are highlighted. There's plenty of them. We'll be here a half hour. Jane B. Stranch, Circuit Judge. Atheists, humanists, and one Jewish plaintiff challenged the federal statutes requiring inscription of the national motto, "In God We Trust," on U.S. currency. Plaintiffs allege that the currency statutes caused them to bear, affirm, and proselytize an objectionable message in a way that, for the atheist and humanist plaintiffs, violates their core religious beliefs, and for the Jewish plaintiff, claiming it renders him complicit in the sins of superfluously printing God's name and destroying God's printed name. Plaintiffs claim that the statutes violate their rights under the Religious Freedom Restoration Act, or RFRA, of 1993, and the free exercise and free speech clauses of the First Amendment, and the Equal Protection Clause of the 14th Amendment, as incorporated by the Due Process Clause of the Fifth Amendment. The District Court dismissed all claims under Federal Rules Civil Procedure 12b-6. For the reasons below, we affirm that decision to dismiss the complaint as one that states no claim, upon which relief may be granted. So it's U.S. District Court versus, okay, we got a Clinton appointee. 2009, we have a previous president, I'm not going to say its name, previous president appointee. The previous president's appointee actually ends up in the majority, and it's the Clinton appointee that's out in left field saying, yeah, it reasonably states a claim for a substantial burden on religious freedom. Really? Plaintiffs are 9 anonymous children. The dissenting judge finds in favor of 39 of them, but not 4 of them, because they didn't state the same claim. Plaintiffs allege that the motto's inscription on U.S. currency places a substantial burden on their religious exercise in violation of RFRA in 3 primary ways. The motto's inscription on the currency allegedly causes plaintiffs to, 1, personally bear a religious message that is the antithesis of what they consider to be religious truth, 2, affirm as true a statement they believe to be false, both that God exists and that we as Americans trust in God, when their religious ideologies mandate that they act with honesty. And 3, it makes them proselytize for a religious claim that is completely contrary to their personal religious opinions. Most of the allegations state that plaintiffs object to carrying, affirming, and proselytizing a message whose content contradicts their religious belief, but some allegations assert that plaintiffs' religious beliefs specifically forbid the very acts of carrying, affirming, or proselytizing the motto. The single Jewish plaintiff alleges that it is sinful for him to participate in an activity that involves the superfluous printing of God's name on secular documents, and that leads to the destruction of that printed name when the currency is destroyed. Plaintiffs allege that carrying and transacting with U.S. coins and bills is often necessary to participate in everyday commerce. By forcing plaintiffs to choose between not using cash and violating their religious beliefs, plaintiffs allege the government has substantially burdened their religious exercise without a compelling interest as required by RFRA. The government's arguments are interesting as far as Congress's choice of currency as a mode of communicating to the American public. Plaintiff's free exercise claim has a similar basis, while further alleging that the challenged statutes are impermissibly, quote, aimed at the promotion or restriction of religious beliefs, end quote. Plaintiffs provide 60 pages of allegations regarding the history of the motto and its placement on money, which allegedly demonstrate the government's consistent, long-standing intent to promote Christian monotheism by including the motto on the currency. Plaintiffs' free speech claim alleges that the government intentionally compels plaintiffs to proselytize when they pass the currency to others. Finally, plaintiffs allege that the government's inscription on the motto on the national currency denies equal dignity to plaintiffs' religious views, contributing to cultural stigma, alienation, and denigration of their views in violation of the equal protection component of the 14th Amendment as incorporated by the 5th Amendment. Stop and think. Did you see any representatives of another religion among the plaintiffs? John Doe child, Jane Doe mother, Gerald Doe father. It was a caption full of no representatives from organizations, entities, claiming to be religious entities. Where was the care what it acts to promote good relations with Muslims? Why wouldn't they petition with these people? It's the Free Thought organization in the caption, and the atheists. They couldn't get a religion to join in with them. That speaks volumes to me. The district court dismissed all the plaintiff's claims for failure to state a claim upon which relief may be granted under Federal Rule 12b-6. It analyzed the RFRA and free exercise claims together and concluded that plaintiffs had not alleged a substantial burden on their religious exercise. The district court found that the plaintiffs had not alleged, they had not claimed that there was a substantial burden on their religious exercise. The dissenting judge in this case says they did. That's where she disagrees. Plaintiffs could avoid cash by using credit cards and checks. The court concluded that cash-only transactions did not compel plaintiffs to proselytize a message that violates their religious beliefs, analogizing to a Supreme Court case that suggested the motto's inclusion on currency was not compelled speech. Oh, that's inconvenient. Supreme Court, 1977. So they took away, it's not compelled speech, meaning you're not speaking by passing the phrase on to other people. If you're not speaking it, it's not your claim of belief in a God. Right there. It's over. The court dismissed plaintiff's free speech claim for the same reason, again relying on the Woolley case. Finally, the court dismissed plaintiff's equal protection claim because it concluded that the challenged statutes did not treat different classes of people disparately. Plaintiffs timely appealed. It's such a sweet story. We review de novo, that means from scratch, a district court's dismissal of a complaint for failure to state a claim. That's because it's a pretty easy review standard. The complaint really has to do a job. And it's pretty easy to review one for a failure to state a claim when you know the criteria of the statute under which somebody's claiming damage, or the constitutional provision, of course. Quote, to survive a motion to dismiss, the plaintiff need only plead sufficient factual matter, which we must accept as true, to state a claim to relief that is plausible on its face. The court relies primarily on the complaint, which we construe in light most favorable to the plaintiffs. Okay? Easy. Legal framework. RFRA, that's the Religious Freedom Restoration Act, provides that government shall not substantially burden a person's exercise of religion by printing a little phrase on all of its currency. Even if the burden results from a rule of general applicability, unless the government demonstrates that the application of the burden to the person is in furtherance of a compelling governmental interest, and 2, is the least restrictive means of furthering that compelling governmental interest. Least restrictive? Yeah, everybody uses money. It doesn't restrict anybody. You can use it. So they have to say is in furtherance of a compelling governmental interest. That's what they argue. This is not a compelling interest, and the government argues Congress communicates that to the public so that we don't lose sight of the values upon which the nation was founded. A person whose religious exercise has been burdened may assert a claim against the government under RFRA. If the claim is successful, courts may craft exceptions to statutory government programs to accommodate religious beliefs, but the government may resist such accommodations with evidence that they would seriously compromise the ability to administer the program. Similarly, although government may be required to expend additional funds for such accommodations, the cost to the government of modifying a program is an important factor in determining the viability of an accommodation for purposes of the least restrictive means analysis, according to the Burwell case in Hobby Lobby 2014, which noted that certain less restrictive means might not be viable if it would be more difficult and expensive to accommodate a governmental program to countless religious claims. Good point, Your Honor. In sum, to survive a motion to dismiss, a complaint must allege the following elements of a RFRA claim. The plaintiff seeks to engage in or avoid engaging in conduct that constitutes an exercise of religion. Number 2, the government has placed a substantial burden on that plaintiff's exercise of religion. And 3, not or 3. And 3, the government either has no compelling interest in imposing that burden, or 4, the government has another less restrictive means of achieving its compelling interest. Okay, that's the argument. Before addressing whether plaintiffs have sufficiently alleged a RFRA claim, We consider the government's argument that some of the plaintiffs lack standing to bring a RFRA claim because they have not established Article 3, in fact, injury. Article 3, standing. You have to prove you will be damaged or you are being damaged. So they discuss standing first. I'm going to skip this part. Let's see. It goes beyond observation of conduct with which one disagrees. That's why they didn't have standing. They simply disagree with the conduct. And so they don't have standing. They're not pleading religion. It's probably the atheists. I don't know. The complaint alleges not only that plaintiffs take offense at the motto's inscription on the currency, but also that the government has burdened. Taking offense, you can take offense to anything you want. That's not part of the statute, is it? But also that the government has burdened all the plaintiffs' religious beliefs by pressuring them to alter personalized conduct in which they regularly engage. Fussy. An allegation that the government is compelling a particular person to violate personal religious beliefs, as opposed to an allegation by a taxpayer that the government has violated a generalized constitutional mandate, states in Article 3, injury in fact. So if you allege it violates personal religious beliefs, it is the allegation of an injury. Construing the complaint in light most favorable to the plaintiffs and accepting its allegations as true, plaintiffs allege injury in fact sufficient for Article 3. That means sufficient for standing, not sufficient for remedy. The complaint alleges that the plaintiffs have sincerely held religious beliefs regarding what they consider to be religious truth. The plaintiffs, besides claimant, allege that among their religious beliefs are that they do not trust in any God, and their religious ideologies mandate that they act with honesty. The gravamen of the complaint is that carrying, that's the gravity, the claim, the thrust of the complaint. The thrust of the complaint is that carrying and transacting with currency containing the words "In God We Trust" is inconsistent with their religious beliefs because, according to plaintiffs' understanding of their religious beliefs, their understanding of their beliefs, aren't they beliefs whether or not you understand them? It causes them to bear, affirm, proselytize, quote, a religious message that is the antithesis of what they consider to be religious truth. Claimant alleges that he believes. He alleges that he believes. No, he believes. He alleges that he believes that, quote, participation in any activity that ultimately leads to the superfluous printing of God's name on a secular document or to the destruction of God's printed name is sinful. He must be the Jewish plaintiff we read about near the caption. Plaintiffs contend that carrying currency in violation of their sincere religious belief is an exercise of religion within the meaning of RFRA. They allege that they are forced to engage in personalized conduct handling currency that is inconsistent with their beliefs. They said handling the currency. They contend that carrying the currency in violation of their religious beliefs is an exercise of religion, the religion of the people who believe the phrase, the motto, within RFRA. Wow, you're exercising my religion because you carry a piece of paper about my religion? I'm not saying I am one or the other religion. I'm just saying as an American, that's my currency. And I don't care what it says on it. Can I get a six-pack or what? Anyway, they're engaging in personal conduct that is inconsistent with their beliefs. Currency is an item an individual owns, carries on his or her person, and uses to engage with the world in a way that is distinct from mere exposure to objectionable speech or ideas. For these reasons, we conclude that plaintiffs have adequately alleged that they seek to engage in an exercise of religion protected by RFRA. Okay. And I didn't get into their reasoning as to they stand behind the dismissal of everything. Applying Haight and Livingston to this case, the inscription of the motto on currency would place sufficiently substantial pressure on plaintiffs to violate their alleged religious beliefs only if using payment methods other than cash is more than a mere inconvenience, such as if plaintiffs have no feasible alternative to using cash to engage in necessary transactions. The complaint includes the necessary allegation, but in a conclusory fashion. Quote, defendants' acts, that means these are the plaintiffs saying that the government's acts, the defendants' acts force plaintiff to choose between either relinquishing their rights to participate in much of their everyday commerce by using our currency or violating their religious beliefs, end quote. The plaintiffs can survive a motion to dismiss only if they back up this conclusory statement with sufficient factual allegations. It would be a big inconvenience. Okay, tell us about the inconveniences. They didn't. The district court concluded, and the government argues here, that plaintiffs can often avoid cash by using checks or credit cards. Dummy. Though access to credit or bank accounts is not universal, not one of the plaintiffs alleges that his or her financial situation forecloses access to credit or checks. Plaintiffs therefore have not plausibly alleged that they lack a feasible alternative to cash for engaging in commerce. That's a good point. How long do you have to carry cash? Only as long as it takes to carry out the transaction that requires it. You could use a credit card, debit card, gold coins from a country that doesn't print "In God We Trust" on them. How long do you have to carry cash? Put it in a jar you don't like and put it on a shelf and use it when you need it. You don't have to put it in the doghouse. Bury it in the cat box. It doesn't matter. You have to look a million miles for a reason to sue somebody to bring this lawsuit. Go out, make, and enjoy the cash. Several plaintiffs allege that they run small businesses or are self-employed and frequently engage in cash transactions for business, both to make purchases and when customers pay for services. So you're going to hold on to the cash no more than 2 days out of 30, out of 10 or 15? Poor baby. But nowhere does the complaint allege that any plaintiffs, including those who are business owners, would suffer serious consequences if they chose to forego handling cash. That's part of the requisites of the complaint. Many businesses do not accept cash payments, but it has to be in the complaint. They didn't allege it. Many businesses do not accept cash payments, and plaintiffs have not alleged anything unique about their circumstances that requires them to do so. In their businesses, they can accept debit card. Avoiding cash might not be ideal for business owners, but that does not mean plaintiffs have alleged a substantial burden for RFRA purposes. Thank you for dragging us out of the quagmire of the left. A bunch of hateful brats that just can't stand anybody. And the Christians are too nice. One day they won't be. Ecclesiastes 3.3. For the reasons stated above, we affirm the district court's dismissal of plaintiffs' RFRA, free exercise, free speech, and equal protection claims and civil lawsuit. Here's the dissenting judge. This is the point to which we've all been traveling. Karen Nelson Moore, cheers. Circuit judge dissenting in part. The national motto and its inclusion on American money is of relative recent vintage. I like this. A nice introduction. There's a few touches on currency, references in here from a constitutional standpoint and historical standpoint that I found pretty interesting. This is one of them. The inclusion on the money is of relatively recent vintage. The first phrase inscribed on American currency was, quote, "Mind your business," end quote. Or you're going to get a musket up your gerrymander. It appeared on the Continental Dollar and then on the Fugio cent. Mind your business. That either means get away from mine or get into business and mind it. Come on, free enterprise. Anyway, I thought that was really funny. And she gives the cite. In God We Trust did not appear on the currency until the Civil War when it was imprinted on coins. Congress mandated that the phrase be included on all coins and bills in 55 and subsequently adopted the phrase as the national motto in 56. Interesting. In their first claim, the plaintiffs argue that the inscription of the national motto, "In God We Trust," on U.S. coins and bills substantially burdens their exercise of religion in violation of the Religious Freedom Restoration Act, RFRA 1993, 42 U.S.C. 2000 B. All but four of the plaintiffs have sufficiently pleaded factual allegations demonstrating that the inscription substantially burdens their religion and have thus pleaded a plausible violation of RFRA. All but four of the plaintiffs have sufficiently pleaded under one particular part of the complaint. I would therefore reverse the district court's grant of the 12b6 dismissal with respect to these 39 plaintiffs. Thus, I respectfully dissent from Part 2A4 of the majority opinion. So a very narrow dissent, and it might have rescued the complaint and forced a remand. RFRA forbids the federal government from substantially burdening a person's exercise of religion, even if the burden results from a rule of general applicability. There is a statutory exception to this prohibition, however. The government may substantially burden a person's exercise of religion only if it demonstrates that application of the burden to the person, 1, is in furtherance of a compelling governmental interest, and 2, is the least restrictive means of furthering that compelling governmental interest. In order to survive a motion to dismiss, the plaintiffs must sufficiently plead facts alleging that the government is substantially burdening their exercise of religion. The facts. They can't just say it. They have to plead facts. How does it burden you? Well, they forgot to mention how they can't use debit card and cash in their businesses. Oops. Those facts, they'll kill you. This is a hate lawsuit. They weren't in there to allege any facts. They got a great attorney to go in there on a whim and an emotion, an agenda, and got the government's boot stuck up them. Where I depart from the majority's opinion is in its analysis of whether the plaintiffs have sufficiently pleaded a substantial burden on the exercise of their religion. They need to plead facts. One way in which the government imposes a substantial burden on an individual's exercise of religion is when it creates pressure on that individual to choose between their acting in accordance with their faith or facing a serious consequence. Really, a serious consequence. You have to use debit card and digital banking, Visa card. That's a substantial burden. And they didn't plead, they said it was, but they didn't say what they would have to go through to make the switch. And those are the facts the majority was looking for when they said they didn't plead sufficient facts. Rather, there is a substantial burden when there is either de facto or de jure coercion on an individual to choose between violating her religious beliefs or facing serious consequences. Serious consequences. Is that an inconvenience? No, it's a serious consequence. In this case, the plaintiffs allege that the government's inclusion of the national motto on coins and bills forces plaintiffs to choose between either relinquishing their rights to participate in much of their everyday commerce by using the nation's monetary instruments or violating their religious beliefs. The Supreme Court has held that RFRA was enacted to prevent the government from effectively excluding individuals from full participation in the economic life of the nation. Hobby Lobby, 2014. Exclusion from full participation in the economy is exactly what the plaintiffs argue is occurring here. There are transactions that are entirely cash only businesses, parking meters, tolls, vending machines, and there are individuals whose participation in economic transactions is limited solely to using coins and bills, children and adults who cannot access credit or bank accounts. If use of coins and bills violates an individual's religious beliefs, then there is a substantial burden if they must use coins and bills in order to participate fully in the economic life of the nation. I agree with the majority that there is no substantial burden on a person's exercise of religion if that individual has only a preference for using cash when conducting economic transactions, but could conduct all the same transactions using an alternative form of payment that does not violate the individual's religious beliefs, like a credit card, debit card, check, etc. And she cites examples that she thinks back her up on that. This is because the foreclosure of a mere preference of payment method, even when that preference is motivated by religious belief, is not severely burdensome if an individual has viable alternatives. But inconveniently making them bear that phrase on a piece of paper they can put on a shelf or in the cat box when they get home until they need it is a substantial burden. It is severely burdensome. That's what I need to get to. How is it a burden of any type to have to carry our money? Nobody else sues around the world. So she finds these 39 plaintiffs should have been sustained. Their complaint was valid. Non-cash forms of payment are not true alternatives to cash or money. Common sense and our lived experience teaches us that. Indeed, the district court, the government, and the majority all acknowledge that numerous transactions in our economy require the use of cash only. It's no big deal. 4 of the plaintiffs do not allege that they must use coins and bills and therefore have not sufficiently pleaded that they face a burdensome dilemma between violating their religion or being excluded from full engagement in the economy. So they aren't the ones she agrees with. I thus agree with the majority that these 4 plaintiffs have not sufficiently pleaded RFRA claim. But the remaining 39 plaintiffs, by golly, have pleaded sufficient facts, which at this stage of the proceedings we must presume to be true. No, all they said was that it substantially burdens us. They didn't say how. It's an allegation, not a fact. That their full engagement in the economic life of this country requires their handling of bills and coins which violates their sincerely held religious beliefs. The government argues that the national motto's inscription on U.S. coins and currency is central to the public proclamation of the fundamental political values that the motto represents. The government claims that its interest in the inscription of the national motto on U.S. coins and bills is compelling interest because it is one of the primary means by which Congress communicates, for the benefit of U.S. citizens and to the broader world, the fundamental values on which our system of government is founded. The government provides no evidence buttressing its claim about the primacy of the role U.S. coins and bills play in transmitting a message from Congress to U.S. citizens and others. In other words, they didn't have any authority saying this is what it means. Furthermore, the plaintiffs vigorously contest the validity of the government's assertions. Consequently, there are no disputed facts conclusively establishing that the government has a compelling interest. But there were no facts that they suffer a hardship or a consequence, an inconvenience, a substantial burden. And she doesn't get to that, jumps right over that to the government's argument. Well, we're evaluating the complaint. That was the plaintiff's argument, not the government's argument. Even if the government were able to establish such a compelling interest, it has failed to demonstrate that the inscription is the least restrictive means of achieving this compelling interest. No, it's the plaintiffs that have to say there's a less restrictive means. The government argues that the placement of the national motto in U.S. coins and bills is the least restrictive means to further its compelling governmental interest because no other phrase is the national motto. Pretty good point. This argument sidesteps the compelling interest the government has asserted. The compelling interest, that's only if you establish there is a burden. Then the government has to plead compelling interest. The compelling interest, as articulated by the government, is not simply having the national motto inscribed on coins and bills. Rather, it claims that the compelling governmental interest is having coins and bills function as a primary means by which Congress communicates the fundamental values on which our system of government is founded. Thus, the national motto is not the least restrictive means of achieving this alleged and compelling interest because Congress could still use coins and bills as such an advertising device without using the specific phrase, "In God we trust," or any other religiously inflected phrase that imposes a substantial burden on users. Excuse me, they're not trying to communicate something else. They're trying to communicate "In God we trust" in this advertisement. Yeah, they could advertise other stuff, but that's not the stuff of currency. We want everybody that touches the currency to know something, make a statement. So the judge is off base. It's not hard to spot in a lot of dissenting opinions on the appellate level. It's not hard to spot in plenty of the majority opinions on the appellate level. Because the government makes unsubstantiated and disputed claims about its compelling interest and narrow tailoring, it has not met the high threshold at the motion to dismiss stage for showing that this applies. Consequently, I believe that the district court erred in dismissing the claims of the 39 plaintiffs who sufficiently allege a RFRA claim. Sufficiently means their complaint that this is a substantial burden to carry around this phrase on the currency that, let me get my magnifying glass and we can see it, is a substantial burden. You pussies. I agree with the majority that none of the plaintiffs have sufficiently pleaded claims under the First and 14th Amendment. We don't need to look at that. And she pokes fun at them. The majority relies on our prior precedent, and they're wrong, she says. For the foregoing reasons, I believe 39 of the plaintiffs have sufficiently pleaded a RFRA violation. I would therefore reverse the district court's grant of the government's 12b6 motion. Thus, I respectfully dissent. And this would be a remand if there were two of these judges that held this. And the plaintiffs would only be able to argue that one particular aspect of the reversal. But we only have one judge, and you see we are one judge away from a major cluster in U.S. District Court if this was remanded needlessly. Stay out of here with lawsuits like this. Go get the case. I gave you the link to it, and download it, and you'll see that when you read the whole thing, there's a couple great reasons they shouldn't have brought this lawsuit. Things about, like money not being a First Amendment expression. You're not speaking when you carry the money. It's a free speech issue. They had to plead religion because speech has already been wiped out. You're not exercising First Amendment when you're in commerce. The use of dollar bills, it's something you own and dispose of. It's a Fifth Amendment exercise of property rights. And so it's not free speech when you give that dollar bill to somebody else. It's an exchange of property at fair market value, hopefully. If you're not being held up, if it's an arm's length transaction, it's a contract. It's the property paid to satisfy a contract. That's not speech. The nature of the activities or product of the person to whom you're giving the money might indicate that the transfer is motivated by an exercise of speech, but contracting like that is Fifth and 14th Amendment all the way. So anyway, go get it and read the case. You'll see, instead of breezing through it like I did, you read the whole thing, and I recommend reading every case I cite. You can't read too much case law. Everything I know came from reading cases. You see me cite cases all the time, and this one will stand out to you, I really believe, as one that really was to waste the court's time, and it was doomed to failure. You're going after the big one. You're telling them to alter the currency of the United States. The United States is about currency, the dollar. Everybody chases it. They grew up with that phrase, and this to me was a no-go all the way. They really needed the support of a couple of religious organizations that say officially in the name of Islam we protest, or in the name of Buddhism, or whatever. But they couldn't muster it. An atheist group and a truth thinker group. Oh, truth is your religion. Okay. Prove I owe a tax, or stop using the word tax. Don't say the word tax. I won't let you. You can't prove it's a tax, so don't use the word tax. Well, I'm going to sue you. Really, it's that stupid. So our national motto, "In God We Trust." Jay Sekulow said he knows the attorney that brought this action, and from what he knows of that attorney, he says, who is very good, just disagrees with him on a few issues. He said this guy is going to take it to the Supreme Court. So FYI, there's a look at a case about "In God We Trust." Go get the whole document, read up on it, and see what the courts have to say about the history of that phrase, our national motto, and look up some of the other referenced authorities about mind your business. I thought that was cool. That is our first phrase on the Continental Dollar. My name is David Myrland. Thanks for joining me here at Take from Caesar. I'll see you in the next tutorial. Thanks very much.
I am sick and tired.
Sit down and shut up.
I am sick and tired.
Sit down and shut up.